Ex-parte hearings in custody cases, a denial of due process. Ex-parte hearings, particularly in custody cases, have long been a source of controversy and injustice within the family court system. The term ex parte refers to a legal proceeding conducted without the presence of one of the involved parties. In custody disputes, ex parte orders often occur when one parent petitions the court for temporary custody or other urgent relief without informing or allowing the other parent to participate in the hearing. While these hearings are theoretically intended for emergencies, where a child's immediate safety or well-being is at stake, their routine misuse has created significant due process concerns. This issue is especially egregious in states like Pennsylvania, where family courts operate under a veil of broad judicial discretion and limited oversight. The justification and reality of ex parte hearings. Proponents of ex parte hearings argue that they are a necessary tool to protect children from imminent harm, such as abuse, neglect, or abduction. Courts justify granting temporary custody orders ex parte under the guise of urgency, claiming that waiting for both parties to be present could endanger the child. However, in practice, the threshold for granting such hearings is alarmingly low, and they are frequently used in non-emergency situations. For example, one parent may allege vague or unsubstantiated claims of emotional distress or instability to gain immediate custody. Judges often err on the side of caution, granting these orders without substantial evidence or verification of the claims. In Pennsylvania, the problem is compounded by the lack of standardization across family courts. Judges wield immense discretion in deciding whether to entertain ex parte petitions, leading to inconsistent and often arbitrary rulings. In some cases, ex parte hearings become a strategic weapon for one party to gain an unfair advantage, knowing that the other parent will be left scrambling to rebut allegations after the fact. Negation of due process. The cornerstone of due process is the right to be heard, a fundamental protection enshrined in the U.S. Constitution's 5th and 14th Amendments. Ex parte hearings inherently violate this principle by depriving one party of the opportunity to present their side of the story before a life-altering decision is made. This is particularly problematic in custody cases, where the stakes are incredibly high, often involving a parent's right to maintain a relationship with their child. When a court issues an ex parte order, the absent parent is typically notified only after the fact, with limited time to respond or contest the decision. Even when a subsequent hearing is scheduled to allow both parties to present evidence, the damage is often already done. Temporary custody arrangements established through ex parte orders can persist for months or even years, creating a de facto status quo that judges are reluctant to disrupt. Scholarly research has highlighted this phenomenon, noting that courts tend to favor continuity and stability, even when the initial custody arrangement was based on flawed or incomplete information. Examples of abuse and consequences. The misuse of ex parte hearings has been well documented in both legal scholarship and personal accounts. For instance, 1. Weaponizing allegations. A 2020 study published in the Family Court Review found that ex parte custody orders are disproportionately granted based on allegations of domestic violence or abuse, which are difficult to verify in the absence of the accused party. While genuine cases of abuse must be addressed urgently, the study revealed that many claims were later found to be unsubstantiated. By the time the truth emerges, the accused parent has often lost significant time with their child, and the court is reluctant to reverse its initial decision. 2. Gender bias. Male parents in particular face an uphill battle in ex parte proceedings. Research by Joan Meyer, a prominent family law scholar, has shown that courts are more likely to believe allegations of abuse or unfitness when they are made against fathers. This bias is especially pronounced in Pennsylvania, where family courts have a reputation for favoring mothers in custody disputes. The inherent lack of due process in ex parte hearings exacerbates this bias, as fathers are often excluded from the initial proceedings and denied the opportunity to refute the allegations. 3. Long-term consequences. Consider the case of a father in Pennsylvania who lost temporary custody of his children after his ex-partner claimed, without evidence, that he had a temper. The ex-parte order granted the mother full custody until a hearing could be scheduled. By the time the father presented evidence disproving the claims, nearly 6 months had passed, during which he was allowed only minimal supervised visitation. Despite clearing his name, the court decided to maintain the existing arrangement, citing the importance of stability for the children. Structural issues in Pennsylvania. Pennsylvania's family court system is particularly prone to abuses of ex parte procedures due to systemic inefficiencies and a lack of oversight. Judges are not required to provide detailed explanations for granting ex parte orders, and there is no standardized process for reviewing these decisions. Moreover, the state's reliance on broad judicial discretion means that some judges may prioritize expediency over fairness, issuing orders without thoroughly considering the implications for the absent parent. The state also lacks robust mechanisms for holding judges accountable for overusing ex parte hearings. Appellate courts are reluctant to intervene in custody matters, and parents who feel wronged by ex parte decisions face significant barriers to obtaining meaningful redress. Legal scholars have criticized Pennsylvania for failing to implement reforms that would curtail the misuse of ex parte orders, such as requiring stricter evidentiary standards or mandating expedited review hearings. Proposed reforms. To address the inherent unfairness of ex parte hearings in custody cases, several reforms have been proposed by legal experts and advocacy groups. 1. Stricter standards of evidence. Courts should require compelling, verifiable evidence of immediate danger before granting ex parte custody orders. Allegations alone should not suffice. 2. Mandatory review hearings. All ex parte orders should be subject to a mandatory review hearing within 72 hours. Ensuring that both parties have an opportunity to present evidence promptly. 3. Transparency and accountability. Judges should be required to provide detailed written justifications for granting ex parte orders, subject to review by higher courts. 4. Parental equality. Courts must adopt policies to eliminate gender bias, ensuring that both mothers and fathers are treated fairly in custody disputes. 5. Public awareness and advocacy. Educating parents about the potential misuse of ex parte procedures can empower them to advocate for systemic change and demand greater accountability from the courts. Conclusion. Ex parte hearings in custody cases represent a glaring violation of due process, particularly in states like Pennsylvania, where the family court system is rife with inconsistency and bias. While these hearings are intended to protect children in emergencies, their routine misuse has turned them into a tool for parental alienation and judicial overreach. By allowing one parent to make life-altering decisions without the other's input, ex parte hearings undermine the principles of fairness and justice that are supposed to guide our legal system. Without meaningful reform, the abuse of ex parte procedures will continue to harm children and families, perpetuating a cycle of injustice that erodes public trust in the courts.